Nathaniel Lee. For almost 4 decades, we've been representing disabled workers. If you've applied for Social Security disability benefits and you've been denied, please contact us. At our law firm, we've been representing disabled workers for almost 4 decades. Jennifer Lee will talk to you about the process, and my longtime partner, Marcia Cossell, will answer all the important questions that are relevant to you and your family. Feel free to call us right away about your disability claims.
Well, I'm glad that you said Social Security disability. Many calls, I would say at least 20% of the calls I get on Legally Speaking are regarding just Social Security. So at what age should I apply for my Social Security? What happens if I apply at 62? Those are not Social Security disability questions. I'm glad to answer them, but they're not disability. Social Security is divided into Social Security retirement, Social Security disability. Social Security disability is a condition that is expected to last 1 year at a minimum or result in death. Social Security disability has 2 types. The Social Security Administration calls it titles. So they have a Title II and a Title 16. Title II is Social Security disability or disability insurance benefits. In disability insurance benefits, the claimant, the person applying for Social Security disability, has worked, has paid in somewhat like a health insurance policy for years, and then is disabled and claims that benefit. SSI is Supplemental Security Income. That is Title 16, and Title 16 is used when the claimant does not have enough quarters paid in to draw on their own benefits. So SSI is a base amount per month. Social Security disability income is a percent of what you've paid in. So always you want Social Security disability income instead of SSI. Because if you've worked, you've paid in. At this point, SSI is $780 a month. And generally, if you've worked, and it depends on the period of time you've worked, you would receive, based on what you've paid in, more than that. So you want disability insurance benefits. Are there any prerequisites? Well, you must be disabled, is all. Even if you haven't paid in, you're entitled to monthly benefits. But the 2 different titles, Title II and Title 16, Social Security disability income or disability insurance benefits, that's Title II, SSI is Title 16, both have different requirements also. But the one requirement they have in common, the condition must last 12 months. So if you're off work and you're home for 9 months and you cannot work, you do not qualify. It must last 12 months or result in death. Yes. But it doesn't need to say, the determination does not need to say, Ms. Jones is disabled. The doctor can, and this is why you need an attorney, the doctors could say the claimant has this condition A, this condition B, this condition C, and then it's the attorney's job to put those conditions together and get those conditions to meet or equal the listings. The listings, it's a medical listing, and the listings are what grants you the Social Security disability benefits. Well, that's a tough question, and it's based on why you're receiving Medicare. If you're receiving Medicare because you are 65 or over, no, you're not entitled to Social Security disability benefits, because if you are receiving Social Security disability benefits, either Title II or Title 16, those benefits stop at age 65 and Medicare takes over. So it depends why you're receiving Medicare. And those conditions are as different as there are applicants, claimants. Well, Social Security, I know what you're trying to say. Social Security disability states earned income. Child support is not earned income. But again, you look at Title II and Title 16. In Title II, disability insurance benefits, you can have any amount of income coming in. Retirement, alimony, any income with no limit. Under Title 16 SSI, there is a resource limit for one person in the family of $2,000 a month, or a married couple, of $3,000 a month. So if your resources coming into the house are more than $2,000, or with a couple $3,000 a month, then that disqualifies you for SSI. No, Social Security disability benefits do not transfer to dependents. But if there are dependents, there are benefits, Social Security benefits, that the dependent may qualify for, but not the deceased disability payments. I am so glad you asked that question. When you apply for Social Security disability, if you've worked, and I'm talking Title II, you can apply online. So you can go on your computer and go to Social Security Disability Administration. Frequently on the computer, if you put in Social Security Disability, you're going to get a number of other websites that are not the official website. So let's say, for instance, you enter in your computer Social Security Disability. You will get ads for other attorneys, which is fine if that's your purpose. You may get ads for Social Security companies that are out of state. Again, that's fine if that's your intention. But I have clients say to me, I wanted to talk to you about Social Security disability, but Social Security gave me an attorney. Social Security, the Social Security Administration, the federal government, does not assign an attorney. So make sure when you apply, if you're applying online, that you look for the official, and it will say the official Social Security Administration website. And then you hit, over in the right-hand corner is a little box that says disability. Enter that box and then begin the process. But before you begin the process, prepare yourself. Make a list of the last 15 years of jobs, why you left, what those jobs entailed, your work history, the income that you have, even though Social Security has that information, approximately the hourly rate and a supervisor's name, and you'll just walk through. The menu is very easy. You just walk through step by step, but it could take an hour and a half. They should mail it to you. But let me go back to your question, because when you asked me how do you apply, I left out SSI. So if you've not worked within the last 5.5 years, you'll need to go to the district office to apply in person. But if you apply online, Social Security, the website will tell you, you need to appear at the district office to apply. We can't take your application online. To go back to your other question, they will notify you online that you've been denied. And be aware, I think it's 82 to 87% are denied the first time. Don't let that stop you. It gives you the appeal process, and it's at that point that you need to get an attorney. You have 60 days to appeal. I would be glad to help you on the 59th day, but it sure would be nice to have a little more time than one day to get this appeal done. Social Security states that in order to qualify, you must have 10 quarters of income. So the important thing to remember is if you are disabled or you feel you're disabled and you push and you push and you don't apply for disability benefits, don't wait too long. Don't wait more than 5 years after your date last worked. You could be earning income, stop working, or try to continue to work. It's a delicate balance. The best thing to do is to call an attorney and ask. There's such a thing as Social Security disability planning for people who want to continue to work, don't want to apply for disability, but you don't want to get out of that insured status when you've paid in and you're disabled. Social Security believes that if you are over the age of 50, you are difficult to retrain. So, for instance, a construction worker who is over the age of 50, who is injured, cannot work, Social Security will state, well, probably would state, that he cannot do that kind of work. His doctor may state that. But he may be difficult to retrain. Over the age of 55, Social Security believes, or the statute says, that you're not retrainable. So, but then you look at the education. So if a person has advanced degrees or degrees that could be used that give them a broader scope of possible employment, then the age may not be as much or as important as a lesser education. If you have done manual labor all your life and now you're injured, you have less options after the age of 50 or 55. Social Security has a term, substantial gainful activity, and you'll see it as SGA. And of course, the government keeps track of what you've earned. So any penny you earn, the Social Security Administration knows you've earned it. If you earn over $1,220 per month, that's for 2019. Last year in 18, it was $1,170 per month gross income. Then Social Security states in the statute that you have attained substantial gainful activity, so therefore you're not disabled. So you can work. Keep track of your hours, keep track of the amount. It doesn't make any difference if you earn the $1,220 at once or over the 1 month period. What matters is the dollar amount.
Were you or a loved one exposed to the weed killer Roundup and developed non-Hodgkin's lymphoma? See if you qualify for compensation by contacting the law offices of Lee, Cossell, and Crowley. Juries have awarded billions of dollars. To receive your settlement, don't delay. Call now to get a free case evaluation from one of the area's most trusted law firms. Call attorney Nathaniel Lee at 317-631-5151. No fees unless we win for you.
Well, that's tough. If you're not able to work, even the less than substantial gainful activity, there is not a program in place to help you. There have been newspaper articles stating people living in cars because they don't have money for lodging, for food. There's not a program that helps you in this interim period. The length of time is lengthy. When I first started doing Social Security disability, we were waiting 3.5 years to get a decision, from start to finish. Because there's 3 parts to this process. You apply your initial application, and you may be denied. If you're granted disability, then you're finished, you're fine. But if you're denied, you have 60 days to appeal the denial. How long does it take for you to receive a denial? It could be 30 days. It could be 6-9 months. And that's only step 1. Step 2 is reconsideration. So when you are denied at your initial filing, we file for you the request for reconsideration. The Social Security then has additional doctors look at your denial and see if the denial was proper or correct. That could take 2 months, 1 month, 6 months. If you get a denial then we do step 3. We request a hearing. At that point, you could be looking at a year, 1.5 years, close to 2 years before you get to a hearing in front of a Social Security administrative judge. And then that's where your question, what do you do in the interim, comes up. Nothing. There is nothing to do to push it along, with the exception there is a process in place for Social Security, and they're called Terry cases, where cases are pushed to the forefront. But it's not for monetary reasons. It's reasons, for instance, I have clients with terminal cancer. If the record shows that that's the case, cases where clients are truly in a life-threatening situation, then Social Security will push that hearing above other hearings. But even that takes 6 to 9 months. Once you have an attorney for Social Security disability and you have filed the request for a hearing and Social Security receives that, there is a process where you can go online and look to see what your monthly benefits are going to be. And monthly benefits can be different for SSI and for SSDI, because for SSI it's benefits for the disabled person only, no dependent benefits. However, if you're getting disability insurance benefits where you have worked and paid in within the last 5.5 years, then you receive dependent benefits, or family. Social Security calls it family benefits. And yes, you can go, or the attorney could go into the website and tell you what your benefits are going to be on a monthly basis. Not at that point, but you certainly can ask someone at Social Security what your monthly benefits would be. Early on, I would ask the Social Security representative, especially if you go into the district offices. I can tell what the client will receive when I am allowed to access their records. So Social Security has a website for attorneys and claimant representatives where we can pull up their medical records, we can pull up documents that have been sent to the claimant, we can pull up work history. Social Security sends questionnaires to family members. We can pull all of that up, and with that we pull up earning statements. And in the earning statement will be what your monthly benefits will be, either the claimant or the claimant and their family. But that's not until we get to the hearing level. So if you need to know early on, you can ask a Social Security representative to calculate roughly for you. Social Security doesn't tell you what you must make your pay, what you must do with your money. No. No. The only time that there are requirements as to benefits is if a Social Security claimant has a representative payee. They've been deemed unable to take care of their own finances, and the claimant appoints a representative payee to receive their check and to take care of finances, utilities, and that representative payee has to respond to Social Security, supposedly monthly, but frequently, as to where the money has gone. That's a protection for the claimant. But if the claimant handles their own monthly benefit, no, there's no requirement what the money needs to go to. However, if there's a child support order and you're receiving disability insurance benefits, Social Security will retain or can retain child support from disability insurance benefits. They will not retain child support from SSI because SSI is seen as an entitlement. Well, workers' compensation is payment to a disabled worker that was disabled at work. The injury arose out of and or was caused by an accident at work. You can receive workers' compensation and Social Security disability. There is an offset though, and it's a complicated math offset, but Social Security can do the math and explain it to you, and I can do that also. But you need the numbers of how much they receive from workers' comp, how much they receive from Social Security. But there is an offset. You can apply sooner. So for instance, someone is in a catastrophic accident and they're in a vegetative state, or they're hospitalized and they're quadriplegic. You certainly understand that those conditions, those disabilities are going to last longer than a year. Or if they're diagnosed with a condition, there are a few diseases or conditions that is an automatic grant for Social Security disability, for instance, ALS, Lou Gehrig's disease. And there are many diseases or disabilities that are automatic grants. And then the attorney falls back on those Terry cases to get a decision if Social Security has denied them previously. That goes back to that SSI versus Disability Insurance Benefits, SSDI. The resources, if you remember, are $2,000 for one person. So if your settlement for this month is going to be over $2,000, no. And what's typically done there is a special needs trust. So the money is put in trust, and if you need the money, then you have to request certain amounts, and it can be granted or denied. If you have disability insurance benefits, that's where you've worked and you've paid in, then yes, any amount of money, a $50 settlement, a $5 million settlement is fine. There's no requirement as to income or lack of income with disability insurance benefits, but with SSI there is. It generally depends on two things. It depends on the type of condition. If you have a condition that is likely to get better or possibly get better, Social Security will do a review of your condition. Usually they wait 3 years. Another marker Social Security would use is age. So if you're 25, 35 and you have a condition, Social Security is fairly certain to review you 3 to 5 years after you've been granted benefits. Not always. Again, it depends on the condition. So if someone is diagnosed with a muscular disease, typically that's not going to get better, and will only get worse, Social Security won't review you. But often they do. Yes, you file what's called a waiver, and Social Security, or it will be set for hearing, and you need representation for that hearing. But what you really need is take this denial to your doctor. If you have a condition that is a disability that lasts longer than 12 months or could result in death, you've got doctors. Take it to your doctor, tell your doctor what's happening. And all the doctor needs to do, assuming you've had ongoing care for these conditions, is make a statement. I saw the claimant in 2014, 15, 16, 17. The condition hasn't changed. The condition has worsened. Here's why it's worsened. And generally, that's enough. The reasons to hire an attorney are many. You've heard all the hoops to jump through, the denials, the appeals, and importantly, early on we spoke about conditions. An attorney can look at the medical records and make a determination if you meet or equal a listing. And what that means is there is a listing of impairments. The claimant must meet those medical listings of impairments in order to qualify. So an attorney can look at those listings, those impairments, and tell that you do meet or equal a listing. Furthermore, Social Security requests medical records, but never a complete set of medical records from beginning to end. Therefore, the attorney gets the medical records and completes the entire picture for Social Security. Additionally, the attorney will talk to the doctors, make sure all the medical records are in, and get the doctor's opinion. The Social Security Administration doesn't have time and will not do all of that for you.